Yes, welcome to another live webinar with Matthews Folbigg Lawyers. I'm Daniel Kim, your host. It's great to have your company, and today we are talking about commercial and retail leases. What you need to know as lessor or lessee when it comes to due diligence, risk management, and commercial negotiations. Now, it's a tricky topic at the best of times, and when you take COVID-19 into account, it's crucial to be in the know. And I'm pleased to say I'm joined live in the studio by a couple of experts from Matthews Folbigg Lawyers, Douglas Brown and Edward Choi. Gentlemen, welcome.
How are you, Daniel?
Thank you. Hey.
I'm very well. It's great to have you on the program. This is a really interesting topic, particularly when you think about the whole COVID-19 situation.
Yep.
Definitely.
People are working from home. I don't know what the demand is going to be like for office space.
Yeah,
moving forward.
it's all going online.
It's-
We've had a lot of landlords and tenants making inquiries, wanting legal advice, so we thought we'd do this webinar.
People left, right and centre are
Absolutely.
renegotiating the deals.
It's
Yes.
tough out there.
It is a tough one. And also for, look at the retail space, things
vacant.
like the social distancing measures,
Yeah, how
the
do
way
you do
you
it?
lay out your store. So many things are going to change.
Exactly.
Yes, well, it is going to be a lot to talk about, quite a substantial amount actually to get through on the show today. We'd like to invite you to join the conversation, of course, by clicking the dark blue hand icon at the top of your screen to ask a question. And when you do so, it'll come through on this trusty old iPad of ours, and we'll get through your questions at the end of the presentation. If I can keep my iPad upright, of course. And if you do happen to leave early, please click the yellow icon at the top of your screen to provide some feedback before you go. It would mean a lot to us if you did. So on your screen now, you will see the 6 topics we are covering today, and they are the Retail Leases Act, due diligence, lease terms, forms of security, lease transactions, and COVID-19 regulations. So those are the topics. And Doug, you felt it was important to start with the Retail Leases Act.
Yeah, a bit of an interesting choice, but I think particularly for landlords, they need to know whether the Retail Leases Act applies. If it's a commercial lease, it's not a retail lease, there aren't that many prescriptions in the legislation for what you need to have in your lease. But with the Retail Leases Act, there definitely is, particularly with a disclosure document. If you don't provide the disclosure document, there can be a lot of liability for a landlord.
Right. And Edward, what types of agreements are covered by the Act?
Well, as the name of the legislation suggests, it applies to retail shop lease, which is also defined in the legislation. So basically, retail shop lease is any type of agreement granting exclusive or non-exclusive occupation of the premises for use as a retail shop, which is also defined in the Act. And then the question may be, what is a retail shop? So the term is defined in the Act as premises predominantly used for the carrying on of businesses listed in Schedule 1 of the Act. So you can think of any retail businesses facing retail customers such as cafes, restaurants, news agencies, bookshops, hairdressers, and etc. And also, one thing to bear in mind is if you run a business within retail shopping center that is not listed in Schedule 1 of the Act will still apply and will be considered as a retail shop lease.
Right, got you. Now, Doug, what about those mixed-use buildings where you've got those big office towers with a cafe at the bottom?
Like here, for example, when you have a cafe downstairs.
Yep.
Well, yeah, look, if you're in generally an office space like a tower, a cafe, something like a cafe will still be considered retail shop lease because it fits in that definition of Schedule 1 that Edward was talking about. If, for example, you're also in a shopping centre, let's say it's tax time, you have like a tax agent set up there in the shopping centre, you see them, they would still be considered a retail shop lease, even though that, an accountant's usually not considered retail because they're in a shopping centre. And there are some exceptions in the legislation, like if it's a shop with a lettable area of 1,000 square metres or more. So your Bunnings, for example, which is huge, wouldn't fit in there. If it's a short-term lease, if it's less than 6 months, a cinema, a bowling alley, and there's a Schedule 1A of the Act which excludes things. So like a car park, for example, is not a retail lease.
Got you. So we've covered what a retail lease is, but Edward, why is it important and what's covered in it?
I think it's just a good idea to start discussing about the disclosure perspective. Well, if the Retail Leases Act applies, the lessor must provide a document called the Disclosure Statement and Retail Tenancy Guide. So basically, the lessor's disclosure statement sets out the basic the key terms of the lease, such as the rent payable, a list of outgoings payable by the lessee, and the estimates, and duration of the lease, also the operating hours. And the retail tenancy guide is basically it's general information which sets out the basic rights of the tenant. So the lessor have to provide these two documents to the lessee at least 7 days before the lease is entered into. Then upon receipt of these two documents from the lessee must provide a document called the lessee's disclosure statement to the lessor within 7 days, just to acknowledge the receipt.
Right. It's in my view as a non-expert, slightly complicated. What happens if you don't comply or if you get it wrong?
This is why it's important, because if you fail to give a disclosure statement and the tenant signs a lease, or if you give a disclosure statement that is materially, it contains omissions, or it has materially false or misleading information, the lessee can terminate the lease within the first 6 months, and they're also entitled to compensation for any loss or damage they suffer. So the lessee can turn around and basically say, this isn't what I understood it to be. I want to get out of the lease, and you're in trouble as a landlord. Now there's an exception as long as the lessor has acted honestly and reasonably, and the lessee is in substantially the same position they would have been if the failure had not occurred. So if it's some minor detail that's left off, that's not so important. But if you're seriously misleading a tenant by your disclosure statement not being accurate, the tenant can walk away and sue you for damages. So that's really important. The landlord must disclose fully and act in good faith.
Got it. Okay, so on your screen, if you can just get that slide up one more time to recap this topic, the Retail Leases Act. So we talked about the lessor disclosure statement, the lessee disclosure statement, the costs, and the mandatory terms and prescribed terms, which is what we're covering. So on to the next topic, due diligence. If we can get that slide up, please, as well. Edward, this is something both landlords and tenants need to know.
Yep. So starting from the lessee's perspective, the key question would be, is the premises suitable for my business? And can I run my business from this particular premises? Usually in most lease document, there will be a clause inserted by the lessor's solicitor saying things like, the lessor does not provide any warranty in respect of the suitability of the premises, in respect of the permitted use. So it's pretty crucial to inspect the premises before entering into the lease. And things that lessee can also do is to obtain title search to confirm that the lessor is actually the registered proprietor of the land. And also, they can do just physical inspections to check whether the premises are vacant. And then they can order the planning certificate to check the zoning to confirm that no DA approval is required for the permitted use. That's all responsibility of the lessee. If you think about it, the lessee should understand that the leasing premises is a substantial commitment considering the amount of rent payable under the lease and the duration of the lease, which will span on up to multiple number of years. So it's due diligence. Doing the due diligence is a key process. Then if, from the lessor's perspective, pretty much the only question is whether the tenant is able to pay the rent.
On that note, we might even just bring that slide up again. People would have got the lessee due diligence. But if we can get the slide up, slide 4, and just take a quick look at the lessor due diligence. Yeah, so you were saying the main questions was, can the tenant pay the rent?
Yep. And so in that respect, the tenant can provide financial statements and make some statutory declaration about the person's assets. And alternatively, the lessor can request a large bond, a bank guarantee to mitigate the risk. And the lessor can also do some bankruptcy search on the guarantor if the lessee is a company.
So there's a few different options there with the due diligence. So moving on to the lease terms, Doug, let's talk about what both landlords and tenants need to look out for.
Yeah, exactly. And as we discussed before about the Retail Leases Act, the Retail Leases Act has a prescribed form. Actually says in the Retail Leases Act, if you don't have these provisions, they apply anyway. And if any of your lease provisions are inconsistent with the Act's provisions override it. So with a retail lease, you need to make sure that you have those proper forms. With a commercial lease, there are some laws that cover the commercial lease, but a lot of it's based on commercial negotiation, what the marketplace is demanding. So there are some things like the Conveyancing Act and the unfair contract terms in the Australian Consumer Law. But basically, with your standard commercial lease, might be 60 or 70 pages. It's going to be very favourable to the. Well, yeah, you don't want to read it. That's why you get a lawyer to do it, like us. But it's going to be 60, 70 pages. It's going to be very one-sided, favouring the landlord. So that's why both parties should get lawyers.
Yeah, gotcha. I mean, I certainly don't want to read 60 to 70 pages. Edward, can you tell us a bit about use and exclusivity?
Yep, the lease will specify the permitted use of the premises, and the lessee must only use the premises for the permitted use. Otherwise, the lessor will be in default. The lessee would want this definition of permitted use to be as wide as possible so that the lessee can change its business in the future or sign the lease without requiring amendment to the lease. The lessee may request exclusive use within the building or within shopping center. And this express statement should be included in the lease and the disclosure statement if applicable. This is obviously favorable to the lessee, but not to the lessor, because it will obviously restrict the lessor's ability to let premises to competing businesses.
Thank you. Now on to the really interesting dot point, which was rent. This is a huge one at the moment, Doug.
Yes, it is. Yes, obviously right now in the market, as you're saying, there's a lot of vacancies as tenants and landlords are renegotiating rent. We're going to discuss code regulations later. What we're talking about right now is rent review. What happens year on year with your rent? Usually there's three options on a lease. There's a fixed percentage increase. The market standard's probably 3% right now. There's CPI increase and there's market review. And generally you have market review when you exercise an option. You get basically what the market rate would be. For commercial leases, often there are two clauses you need to watch out for if you're a tenant. There'll be a ratchet clause which says that the rent can't decrease year on year. So if you've got CPI can go backwards. CPI is nothing right now, but it could go backwards. Market review, right now, as you said, the market rent for a lot of premises will be lower than it was a year ago. Some commercial clauses have a ratchet clause saying it can't be lower. Those clauses are void in retail leases. And again, not to sound like a broken record, that's why the Retail Lease Act is important, because there are a lot of prescriptions on what you can have. Also in a lot of commercial leases, it will say the greater of a percentage increase or CPI increase, that also is prohibited under the Retail Leases Act. I mean, and we're trying to make this practical and talk about the current market situation. Inflation's very low. You're not going to get much benefit as a landlord by putting CPI in, so you'd probably be better off to put a percentage increase. Another thing that often the parties have disputes about what the market review is. So I have a 3-year option. When I exercise it, you say the market rent. I dispute your determination of the market rent. Usually the lease will say that the landlord will decide what it is. He'll tell the tenant. If the tenant disputes that, then often they might get valuation done. The Retail Leases Act says that you have to get 2 valuers to determine the rent. And if there's a dispute, you can go to NCAT if there's a manifest error.
Sure. A lot to think about there for both parties.
Exactly.
Okay, well, on to the next topic. I've got no idea what this is, Edward, but outgoings. What on earth is an outgoing?
So outgoings are pretty much the lessor's cost in respect of keeping and maintaining the premises. Mm-hmm. And lessee is often required to pay a percentage of these lessor's outgoings, usually referable to the area of the premises as a proportion of the building as a whole. So for example, if this building has like 10 levels, and you're currently occupying level 7, it's 10%. So in the lease, there will be a particular, usually in the reference schedule, which will specify the percentage of outgoings that the lessee is required to pay. Also, lessee must pay directly to suppliers for some of the essential services like gas, electricity, internet, and phone. So it's important to make sure that the definition of outgoings in the lease is pursuant to what the parties have agreed upon. And that's part of the due diligence process as well. But in the lessor's disclosure statement, it will usually set out what outgoings are included. So in order to avoid, if you want to avoid any uncertainty and doubt, one way of doing so is you can just pay gross rent, which is an inclusive amount of all the outgoings. That's one way of doing so if to avoid any hiccup in future.
Right. So basically, it's helping you navigate hidden costs.
Exactly.
Yes.
Yeah. Got you. Well, speaking of hidden costs, our next stop point was fit outs. And I'm imagining if you take out a new commercial lease and your kind of business is different to the previous tenants,
Substantial cost.
There'd be a fair bit
exactly. And
involved.
it's not something that tenants often don't think about. That's very important. You're right there. So
we're never getting at the same time.
look, generally the tenant will need the landlord's permission before it undertakes a fit out. So usually the tenant will have to provide plans to the landlord. Some of the conditions will be things like you might need DA approval. You have to use qualified builders that we approve of. We have to approve the plans. It's generally better that if you're going to go into a new lease that you discuss these things before you sign the lease. It'd be a bad thing if you signed the lease and then say, "Oh, we want to do this fit out. Oh, we don't approve." Then you're in a bit of a trouble. Sometimes too, landlords will pay a percentage of the fit out costs as an incentive to get you in there. If you're going to be a long term tenant, maybe I'll pay $100,000 towards your fit out costs, but you commit for 10 years. So that's something too that you can negotiate. It's best to have, if you're a landlord, you probably don't want to put you probably don't want to mention this in the lease, because when you register a lease, this is something we'll talk about later, when you register a lease, it becomes a public document. So if I'm in level 6 and I see that the landlord gave you $100,000 to do your fit out for level 7, I might suggest, hey, maybe I should get some of that too. So if you're a landlord, maybe you want to keep that confidential, have it in a side deed. Yeah.
Right. So if you do have it in a side deed, is that legally enforceable?
Yes, it is, but it's not registered. So
Gotcha.
it's a separate agreement.
Okay.
No one else needs to know about it.
Right. Well, it's interesting because the next topic is fixtures and which parts is which.
Exactly.
If people get involved with this kind of arrangement, I suppose it comes to a point where you're like, well, how much belongs to the landlord and how much belongs to the tenant?
Yeah, exactly.
Yeah.
Yeah.
Edward, I think that was your dot point to talk about.
Yeah.
Yeah. So in terms of fixtures and fittings, the general rule is that any personal property situated on the premises at the commencement of the lease is the lessor's property. And any property brought onto the premises after commencement of the lease is lessee's property. So where the lessee's property is affixed to the premises, such as replacement light fittings or maybe new carpet, something not easily removed without damaging the property, then it becomes part of the premises and becomes the lessor's property after the expiry of the lease. So it's to avoid any uncertainty at expiry, it's important for the parties to agree on the breakdown of the lessor's and lessee's property and which of the lessee's property can be removed by the lessee and which of the lessee's property are to be retained by the lessor at the end of the lease.
So I might give an example of that. Let's suppose you don't like the light fittings, so you put in chandeliers. Very expensive. Who owns it? Because a chandelier could become considered a fixture, could be landlord's property. You don't want to give him expensive light fittings for the next tenant. So that's an example of what Edward was talking about. You want to set out straight away. Whose chandelier is that? Is that ours or yours?
You know what's interesting? It's the kind of stuff that when you say it out loud, it sounds like common sense.
But you don't think about it.
No,
That's the point.
'cause
You
you
need
get-
to think about it at the start. That's our message. I
Buried
guess.
under the 60 to 70 pages of documents.
Exactly.
Yeah.
Yeah.
Right.
Yeah.
Okay, so moving on to thanks for that. Moving on to make good obligations. What on earth is a make good obligation?
It doesn't sound interesting, but this is actually something that parties always have a big dispute about. You get to the end of a lease and there's damage to the premises and the tenant will say, that wasn't mine, it was like that when I got here. If you've ever rented residential premises, you know what I'm talking about.
Yeah. Yep.
So look, pretty much every lease, every commercial lease will have a make good provision. It says you have to restore the premises to the condition they were in at the commencement of the lease. There's an exception for fair wear and tear, which is like you might say run down the carpet a bit. That's accepted if you've been there for a few years. It's always important, again, if you were to rent residential premises, you do an inspection at the start, you might take photographs. It
If you
applies
a
the
little
same.
form, we're like, no, it was like this when I got here.
Exactly. But that's part of due diligence. That's what a commercial tenant should do. I might give an example. Air conditioning is one thing, right? You come into you might go into a building that has a very old air conditioning unit. The lease will say that you have to repair and maintain the air conditioning. Now, what if that air conditioning is a piece of junk? It's 20 years old and it's going to break down during the term. Is the landlord going to turn on you and say, right, you've got to pay to replace it? That's something that you've got to work out. That's why inspection is important and you have an agreement at the start of the lease. And again, like we were talking about rent incentives, maybe you want to say to the landlord, look, I'll rent the premises, but I want you to replace the air conditioning. That's a condition. One thing that we'd always say to tenants, unless you're a long-term tenant, is you don't want to agree to structural repairs or capital improvements. Those are things that a capital improvement would be like improving the premises. And structural repairs would be things like if there's a design flaw, if there are cracks in the building, damage that wasn't caused by you. Because you don't own the premises, you don't really have an incentive to spend all that money on it. And yeah, I mean, for some of these costs, if you're a long-term tenant, like if you're there for 20 years, maybe you would pay those costs. Maybe if you're shorter term, you may be willing to pay part of those costs because it benefits you. Like a new paint job to the premises would be good. But you might want to come to an agreement with the landlord about that. Also, latent and patent defects. If you're a tenant, you don't want to be responsible for latent defects, which are defined as damage that you can't tell on observation, something that might only become apparent years later. We'd always say, again, and this is a theme we're talking about a bit, is that you want to turn your mind to these things at the start of the lease, not at the end when it becomes a dispute. So it's always better to have agreements to inspect the premises. If there's any problems, have it well documented at the start. Whose responsibility it is to pay for that?
Gotcha. Because repairs, maintenance, refurbishments
Can add up.
These are going to be big costs if they go unchecked. Well, speaking of costs, that's our last stop point. Edward. Costs and indemnity.
What is that?
I can read the word, but what does it mean?
I'll start with the cost. So if the Retail Leases Act applies, which means we have a retail lease, the lessor cannot charge the lessee for its legal cost incurred in respect of preparing and negotiating the lease document. So basically what that means is each party will bear their own cost. But it's slightly different in commercial leases because it's just a matter of negotiation. If from a lessor's perspective, if we prepare a commercial lease document for a lessor, we will certainly include a clause which will say something along the line, the lessee is to pay 100% of the lessor's legal cost for preparing and negotiating the lease. But in the end, it's always up to the parties to decide. So it's just for them to negotiate. What we can do also if the lessee, so ultimately it depends on the bargaining power between the parties. So if the lessor is desperate and the tenant might say something like, we will just pay 50% of your cost, or alternatively, we can have some sort of like a maximum cap on top of the amount of lessor's legal cost payable by the lessee. So in the end, it's up to the parties to decide when it comes to commercial leases. But with retail lease, the Retail Leases Act strictly prohibits the lessor from charging the lessee for that cost. So that's something you have to bear in mind. In respect of indemnity, just to give you an example, what that means is normally in commercial leases, the lessee has to indemnify the lessor's legal cost and other expenses if the lessee is in default of the lease. So for example, if the lessee doesn't pay rent for 3 months and the lessor gets upset and engages a solicitor to prepare a letter of demand, the lessee will ultimately be liable for the lessor's legal cost for engaging the solicitor to prepare a letter of demand, serving that letter, and if that matter ends up in court, the lessor will have to pay the the lessee will have to pay the lessor's court cost as well. So that's what the indemnity is about.
Got you. So I pay for all the legal trouble.
Everything.
I
That's
incur.
right, yeah.
Yes. Yes. I see. If we can just get that slide up again, just to recap the lease terms. So we've had the form of the lease, use and exclusivity, rent review, outgoings, fit outs and alterations, fixtures and lessees property, repair, maintenance and refurbishment obligations, and costs and indemnity. So those are the key things to look out for in the lease terms. And if we move over to the next slide, because the topic is now security. Doug, this was something you brought up earlier on in the conversation about having different options of exploring.
That was about rent. But I think also, we were talking about due diligence. This sort of touches on due diligence. Security for a landlord is very important. And we're going to discuss bonds, bank guarantees, and personal guarantees, and what should you go for. So with a bond, the advantage for a landlord is you have cash in your pocket. It's guaranteed, right? One disadvantage, though, is for a retail lease. Again, coming back to our point, retail leases. For a retail lease, the landlord has to lodge the bond with the New South Wales Small Business Commissioner, and they will decide if there's a dispute about the bond, who gets it. So your hands are somewhat tied if you're a landlord in a retail lease, but for a commercial lease, it's great to get a bond. For a tenant, again, and that's sort of a flip side, the New South Wales Small Business Commission will mediate a dispute about the bond money, so you've got a bit of an advantage there, but you've got to come up with the cash, and that can be a bit difficult. That's why sometimes tenants go for bank guarantees. So a bank guarantee for a landlord, the advantage is, well, it's a continuing security, so as long as the bank guarantee doesn't have an expiry date or conditions. Usually we'd ask, when we're acting for landlords, we'll say no expiry date, no conditions, we can just, it's payable on demand. The disadvantages for a landlord of a bank guarantee is that you have to keep the original. If you lose it or if you use a photocopy, they're not going to accept that. The banks can sometimes be slow to cash a bank guarantee. You know, I've had experience with this as a lawyer for a landlord. A bank guarantee is supposed to be as good as cash. It's supposed to be like a bank check. I hand it over, you give me money. But sometimes banks will, stuff around a bit and they'll be making inquiries. They're not supposed to, but they can. Sometimes it can be a delay of up to a month before you get your money, which is not ideal if you're a landlord. Again, that's the banks not doing their job, in my view. And the banks are not supposed to call up the customer and say, oh, your landlord's here and wants 100 grand. Are you happy for us to? They're not supposed to, but... And I'm not saying they do, but there's a lot of administrative hurdles sometimes to get a bank guarantee cashed. For a tenant, what's the advantage of a bank guarantee? Well, you don't have to come up with the money up front. You will have to pay fees to the bank, but you don't have to come up with everything up front. It can be a bit of an administrative burden getting a bank guarantee organised. I mean, sometimes it holds up lease transactions because the tenant has to get the bank on side. You obviously have to compensate the bank if the bank guarantee is called upon, and you don't have a say. If there's a dispute, the bank will supposed to cash it. You can't stop the bank from doing it, and you have to just deal with any subsequent disputes with the landlord yourself. The bank's not going to be on your side. They're going to cash the bank guarantee, then say you have to come up and pay us, and you're basically then having to deal with the problem with the landlord on your own.
Yeah, right. So pros and cons for both.
Yeah.
And so we've got bonds, we've talked about bank guarantees, but Edward, the third dot point was personal guarantees.
Yep. So in addition to bond and bank guarantee, if the lessee is a company, sometimes the lessor will ask the directors of that lessee company to provide personal guarantee. So that's favorable from the lessor's perspective, because the lessor will have a recourse to the personal assets of the guarantor if the lessee company is in default. So for example, if you have a house and you provide personal guarantee and your lessee company is in default, and I'm the lessor, I can have recourse to the house, which is, so from the risk perspective, that's favorable to the lessor. But it's also important to bear in mind that the guarantor may not have sufficient personal assets to satisfy any debt. So it's important as part of the due diligence process, if from the lessor's perspective, if the lessor were to seek personal guarantee from the director, it's important to investigate what sort of personal assets are owned by the director. But from the lessee's perspective, there's actually no advantage. That's something which is not favorable to the lessee. because obviously your personal assets are at risk in case the lessee company is in default.
Yeah, it's not very good for a tenant to give a personal guarantee. It defeats the purpose of having a limited liability company, really, but a lot of landlords will demand it.
Right.
Yeah.
Is it a common thing in the marketplace?
Pretty common.
Yes.
Yeah, usually to ask for at least the director to give a personal guarantee.
Yeah.
I'd resist it if
Yeah.
possible.
Yeah, I can see why. Now, we're meant to cover another big section called
Yeah.
leasing transactions, but I've got a feeling, and I might make a call as the MC here, why don't we just skip ahead to the
Do
really
it.
interesting part, and let's talk about the impact of COVID-19 on leasing.
Exactly.
We might have to skip
do that.
forward. How many slides do we have to skip forward?
A
But
lot. Here we are.
There we go, yes.
Good. Okay, so we're now onto it. So COVID obviously very disruptive in the market, as we've alluded to. On 7th of April, the National Cabinet announced a code, a National Cabinet Mandatory Code of Conduct, it was called. That was announced before it actually became law. And in New South Wales, the actual regulations didn't come in until the 24th of April. And they're scheduled to run for 6 months. They're scheduled to be repealed on the 25th of October. But we don't know if that's going to be extended yet. We've seen JobKeeper extended. We've seen the changes to insolvency laws extended. So this might continue on, which would not be good news for landlords. But Edward's going to go into what the main provisions are.
Yeah, so main provisions contained in the regulation is this. It applies to both retail and commercial leases, which were entered into before the 24th of April 2020. And it applies to lessee if it's classified as an impacted lessee as defined in the regulation. So what's impacted lessee is it's a lessee who qualifies for JobKeeper have annual turnover of less than 50 mil for the financial year ending 30th of June 2019. So if the lessee is an impacted lessee, a lessor cannot take any prescribed action such as terminating the lease, calling on a bond or bank guarantee, exercising right of entry, and enforcing any other rights it has under the lease against the lessee due to the failure by the lessee to pay the rent or outgoings. And the regulation also gives the impacted lessee a right to renegotiate with the lessor in terms of rent reductions in proportion to their reduction in annual turnover during the prescribed period, which is defined as the 6-month period from 24th of April 2020 to 24th of October 2020.
So that's only like a month and a bit away.
Yes.
That deadline.
Yeah. So there's obviously been a lot of disputes during that time.
And have there been any court actions?
There has been. So there's finally been a decision that's been handed down. It's called Sneaker Boy 2. Sneaker Boy is a retail store. And that decision came out a couple of weeks ago. So we've actually been, as lawyers, been struggling to see, because the legislation is quite ambiguous. It's quite unclear for the landlords and tenants. It was sort of rushed through by the government, understandably trying to deal with this catastrophe. So I guess the main thing with Sneaker Boy, they made this decision. It was Justice Robb in the New South Wales Supreme Court. And he handed down a lot of decisions that are a bit concerning for a lot of landlords. So just to summarise, with what Edward was saying, the COVID regulations say that when there's a rent reduction, you have to have had a loss of turnover at least 30% from 2020 compared to 2019. You should be given a rent reduction proportionate to that. Half of that should be a waiver, half of that should be a deferral, and the deferral you would have minimum 2 years to pay it back. So it's very generous. It said the parties have to negotiate in good faith, and it also sort of stopped a landlord from taking any court action until the parties had gone to mediation and tried to resolve their dispute. So it sort of, landlords sort of had their hands tied behind their backs. So this decision by Justice Robb in the Supreme Court, Sneaker Boy, is quite significant. So he made a number of comments, and some of the comments included that, he confirmed that a landlord basically cannot terminate a lease for non-payment of rent as long as the regulations are in force. So until October 2020, even if a tenant might not be paying any rent, you can't terminate that. He also said that the parties have to attempt mediation before court action can be commenced. And he said even if one of the parties isn't acting in good faith, or if they're not participating in negotiations or providing proof, still there might be a restriction on a landlord terminating a lease. And it's sort of unclear about how that mediation process will work, because my understanding of mediation is a mediator just gets the two parties in the room, tries to hatch out a deal. If it doesn't work, the parties walk away. So how does that really resolve this? That was left unclear by the judgment. His Honour also said that the definition of tenants trade in the regulations referred to all of the tenants' turnover, including internet sales, including all locations, including all related parties. So it's not just if you're rent at a particular location, you've had a downturn. It's your whole business, all related companies, all internet, all wherever your stores are located. So it's looking at the whole picture, not just a particular store. And he said, he also, another thing that was quite concerning, where he said that even after the prescribed period ends in October 2020, there might be an extension of the provisions. It might extend for a further 6 months. He called it a subsequent reasonable recovery period. So landlords may be required to continue giving rent concessions for a further 6 months, even after the regulations are supposed to end in October. And he said that will depend on whether the regulations are repealed or extended. But his reading of the legislation right now is that you can't terminate even after October if the reason for termination was non-payment of rent during this period. Likewise, you can't sort of take punitive action on the day that it ends and just say, well, you didn't pay us rent 3 months ago, so get out. Again, landlords might be a bit restricted in what they can do. And another comment His Honour said was that he said the parties might be able to have more than one renegotiation, which means that a lot of landlords and tenants have been coming to deals about rent negotiations. His Honour left it open to the parties to maybe have more than one renegotiation, which again doesn't help the landlord. So I think this whole decision is very favourable to tenants, and it suggests that the landlord's obligation to provide further rent relief and not take action against the tenant might extend even beyond October. So we're very interested to see if the regulations do get repealed, or if they get amended, or if they get extended, and what the effect of that is. And we think there are probably going to be more decisions. This decision could be appealed, or there could be new ones that say that a lot of these comments don't apply. So this is still very unclear as to the effect of all this. It's really just lawyers' interpretations at this stage.
That's pretty much indicative of whole 2020 in general, isn't it?
Yeah.
So many things are
Very
unclear. I mean, this is a huge decision to be made, but then where does it go afterwards? We don't know. They don't know. And it's tough for everybody because, I mean, you're saying it's hard for the landlords with the way it's been described and the way it's been implemented, but then you think about it from the tenants and they don't have business coming through the door. They can't...
landlords have a business too.
That's what
Their
I mean.
business is getting rent.
That's what I mean.
So
Their
everyone's
business,
hurting. Yeah, exactly.
It's really tough. Really, really tough gig for everybody involved. But I think we might pause there to start taking questions from the audience. And to get involved with the Q&A, a quick reminder, it's the dark blue hand icon at the top of your screen. And we'll get some questions going through for Doug and for Ed. We do have a few that have come through already. But yeah, if you've got more, it's the dark blue hand icon. So do get involved. If we run out of time, we'll make sure we get to you offline also. So here we go. We've got a question coming through from Richard. Since COVID started, I can no longer afford to pay my rent. That's pretty much what we've been talking about. And the landlord has been really difficult. Can I use this as an excuse to get out of my lease? Edward, I might throw to you for that one.
So as we discussed about the regulations just prevents the landlord from evicting the tenant. And it gives the tenant a right to negotiate any rent reductions with the landlord. It doesn't actually give any right to the tenant to terminate the lease just because he or she can't pay the rent. So the answer is no.
Got you. Thank you very much for that question, Richard. So you can renegotiate, and like Douglas said, you get to renegotiate more than once, but you don't have the power to terminate on your own. Okay, thank you. Next question coming through from Denise. Denise is asking, I've been behind on my rent since COVID started. Can the landlord kick me out when the COVID regulations expire? We sort of almost touched on that one, but...
Well, that was an interesting decision by that court, and it sort of left it open. He said, you're not supposed to take action against a tenant for anything that happened during this 6-month period. So presumably the day after the legislation repealed, you can't take retaliatory action against them. But His Honour also said that it depends on whether the regulations are repealed, because once they're repealed, they don't exist anymore. So there's really nothing stopping you. So we really don't know. I mean, this was one court decision I think the regulations were very ambiguously drafted. They were put out in a rush because they wanted to reassure the market, the sky's not falling in. So we don't really know at this stage. It's still unclear, and the situation might change. But I would say landlords be cautious before taking action against tenants.
Yeah, so there you go, Denise. Be careful is Douglas's advice. A question from Dorothy. My business is a cafe and it's not located in a retail shopping centre. Can it be still classified as a retail lease? Edward, I think this might be a question for you.
Yep. So I think we discussed about this earlier. So if you run a cafe, that's obviously included it's one of the listed business in Schedule 1 of the Retail Leases Act. So that's obviously a retail shop. So it doesn't have to be located within the shopping centre in order for it to be classified as a retail lease.
Okay.
Yep.
Cool. Yeah. Thank you very much, Dorothy. Another question coming through from Alicia. I own a news agency in a shopping centre, but I never received a disclosure statement. Can I get out of my lease? Maybe I'll throw this one to you, Doug.
You can within the first 6 months of the lease. But again, it has to be a material omission or a material misleading statement. So if there was details missing or something, I think she said that she never got one. Is that what she said?
She said, I never received a disclosure statement.
Right. Yeah. So that applies, yeah. So within the first 6 months, you could get out of the lease. Also, you could potentially, if there was some misrepresentations made, verbal misrepresentation, you could have a claim there, but it's time limited. So I'd probably if I were you, Alicia, we're not giving legal advice here, I'd probably get legal advice first if you're looking to terminate a lease.
Is it a common occurrence, though, not getting the disclosure statement properly?
Well, sometimes landlords, like as we started, this presentation, sometimes landlords don't realise it's a retail shop lease. They don't realise the obligations. They just say, I'll just put out a lease. A lawyer should know. You should always get a lawyer's advice. Sometimes real estate agents don't know about this either.
Oh, really?
So, it's always very important to figure out, does the Retail Lease Act apply? And then that will frame how you prepare your lease documents.
Got you. Well, thank you for that question, Alicia. The answer was, go get a lawyer. that was the answer.
Get legal advice.
Yes, get legal advice. Another quick reminder, it's the dark blue hand icon to ask questions to Doug and Edward. Another question comes through from Brett, and Brett is asking, why are there such special conditions for a retail lease, not so with a commercial lease? I'll go to either of you gentlemen.
That's a good point. I think there should be more regulation of commercial leases. What do you think, Edward?
Yes, I agree. Yeah.
Like we said, there's 70-page leases sometimes. If you're a punter, you don't know what that all means.
No.
The Retail Leases Act helps you a lot as a tenant. The commercial tenants are on their own, basically. And this COVID regulations has helped commercial tenants. But I think there should be a permanent code of conduct. What do you think?
Yeah.
It's an interesting scenario, isn't it? With the commercial tenants, especially if you think about office space, everybody's working from home. Like, I say everybody, you know what I mean.
Of course, yeah.
And because of the duration of this pandemic and the whole work from home and the lockdowns, maybe it's going to become the new normal to work from home, and coming to the office might become a special thing.
Exactly.
If that's the case, what's going to be the impact on demand for office space?
Exactly.
And then does that have more impact?
What about all these new offices going up in the city, all this construction?
Who's going to stay there?
Exactly.
Who's going to want it? Yeah.
Exactly, yeah.
Lots of interesting things to talk about.
Yeah.
We are out of time, though, unfortunately. So all the other questions that we weren't able to get through, we will get back to you offline, of course. And that does bring us to the end of the program today. Douglas Brown, Edward Choi, thank you very much.
Thank you. Bye.
Great having you on the webinar. And of course, please remember, today's webinar is intended as a general guide only. We encourage you to contact Matthews Folbigg Lawyers directly for some specific legal advice that will be tailored to you or your situation. And of course, before you go, please complete the quick 3-question survey to which you'll be automatically redirected. We'd love to hear from you, so do give us your thoughts and feedback, and it'll help us form better programs moving forward. Today's webinar will be made available for on-demand viewing, and we'll be in touch with you in the coming days with all of those details. So thank you very much for your company once again on today's live webinar, and until next time, from us here in the studio, it's goodbye for now.